We've now got a major update in the Colorado trial seeking to disqualify Donald Trump from the ballot. After a state court judge, Sarah Wallace, found that Trump did indeed incite an insurrection, but that presidents aren't subject to the 14th Amendment, the decision is now being appealed by both the watchdog group that brought the lawsuit for not outright disqualifying him from the ballot, and by the Trump team for ruling that he incited that insurrection. The case now heads to the Colorado Supreme Court, which has agreed to hear the case, and I should note that all 7 justices on the Colorado Supreme Court were appointed by Democratic governors. I'll get back to that part in just a moment. But first, I want to discuss this finding that the ban doesn't explicitly apply to presidents, although stating that it applies to officers of the United States. Judge Wallace wrote, quote, "After considering the arguments on both sides, the court is persuaded that officers of the United States did not include the President of the United States. It appears to the court that for whatever reason the drafters of Section 3 did not intend to include a person who had only taken the presidential oath." But I would argue that this doesn't even pass the smell test. Why would the authors of Section 3 of the 14th Amendment go to all the trouble of banning insurrectionists from serving again in office, but leave a loophole solely for the president, who is the most powerful person in government? In other words, the authors didn't believe that senators and members of Congress and any other elected officials who'd engaged in insurrection should be allowed to serve again, but that a president who could do the most harm, who would wield the most power, should be able to? If there's logic in there, I've yet to find it. And that's a point that was echoed by my Democracy Watch co-host, Mark Elias.
It doesn't make any sense. It doesn't make any sense from a legislative intent standpoint, as you point out. Why would they pass this anti-rebellion and insurrection clause and somehow leave the president out? Like, why would that? How would that make any common sense? But beyond that, to read it out, you have to say that the president is not an officer of the United States. I mean, the president is the commander in chief, and the president is the chief officer of the United States. He is in fact, under conservative theories, where they talk about a unitary executive, he oversees. He is the only officer, in their view, of the executive branch of the United States. So I don't know how the judge got where they did to say that somehow the being president is not an officer of the United States. Clearly, the president takes the oath that's required by Section 3, and as you point out, the policy behind this, the purpose behind this, would clearly find the president fitting within it.
Now, I mentioned that the composition of the Colorado Supreme Court is that all 7 justices were appointed by Democrats. In terms of why that's especially important, here again is Mark Elias discussing how Judge Wallace's decision may actually have been a strategic play.
Look, some people have speculated that Judge Wallace is actually playing a very long game, a very smart long game, which is the judge found, as a matter of fact, that the former president engaged in insurrection. Okay, that is a factual determination, and that is entitled to great deference when it's reviewed by higher courts. She determined that as a matter of law, that the president does not fit within the definition of officer of the United States. That is a question of law that is reviewed afresh, what's called de novo. The court, by the appellate courts, they look at that for themselves. So if you wanted to take a more strategic view of this, you would say, look, what the judge did here is, knowing this would go up on appeal, she made the essential factual finding and knew that the legal determination was going to ultimately be decided by a higher court. And so she did the hard work. Now, whether she didn't take that extra step because of the tremendous pressure, the doxing, the intimidation, the threats that come to everyone who stands up to Donald Trump, I don't know. But it certainly may have been in her mind. I don't know.
In other words, even if, like me, you believe that Judge Wallace made a mistake by refusing to disqualify Trump from the ballot, it may not actually matter much, considering it was always a certainty that this case would be appealed to the state Supreme Court. But by ruling that Trump incited an insurrection as a matter of fact, and then ruling that the insurrection ban doesn't apply to presidents as a matter of law, she may have teed up the higher court to overturn her ruling and decide that because Donald Trump did incite an insurrection as a matter of fact, that the insurrection ban does apply to him and that he should be disqualified from the ballot. Of course, even the Colorado Supreme Court will likely not be the final arbiter of this decision, as it'll almost certainly be taken up by the U.S. Supreme Court, where we'll get a final decision on this issue. And then all of the other cases regarding this issue with scattershot rulings and decisions will ultimately comport with whatever the Supreme Court decides. And given the fact that states will need to print their primary ballots within the next month or so, we're all but certain to get a ruling on this issue, a definitive ruling, in the coming weeks. And look, I want to be clear that regardless of how the Colorado Supreme Court rules, and regardless of how the U.S. Supreme Court rules, what we already know as a matter of fact is disqualifying unto itself as far as Trump is concerned. The notion that America should elect to the highest office in the land a person whose final act in office was to undermine the results of a free and fair election and to put an end to the 200-year-old tradition of peaceful transfers of power is absurd on its face. And if his culpability wasn't already clear, the fact that a judge just confirmed as much is all the proof you need that he is an enemy of the United States of America, its Constitution, and the voters who already soundly rejected him at the ballot box.
We begin tonight with breaking news from Colorado, where the state Supreme Court has just disqualified former President Donald Trump from Colorado's 2024 primary election ballot. In its ruling, the court cited the 14th Amendment, finding that Mr. Trump engaged in insurrection for his role in the January 6th attack on the U.S. Capitol. Today's ruling is stayed until January 4th to allow for an appeal, and the legal fight is just beginning. And late word, the Trump campaign is responding tonight. Garrett Hake is following this. He has the latest details for us. Garrett, could this have an impact on the Republican frontrunner?
It absolutely could, Lester. This is a stunning decision here from the Colorado Supreme Court, which tonight ruled that former President Trump is disqualified from serving as president again, citing his actions on January 6th, then ruling that, quote, because he is disqualified, it would be wrong to allow him as a candidate on the Colorado primary ballot. The court here citing the 14th Amendment of the Constitution, which says that no person can serve as an officer of the United States who engaged in insurrection or rebellion against the U.S. The Trump campaign tonight calling this decision completely flawed and vowing a swift appeal to the U.S. Supreme Court. Now, all of this comes as other state courts have heard similar challenges but ruled in Mr. Trump's favor. This ruling, Lester, has been temporarily paused pending Mr. Trump's appeal.
First state to make a move to keep Donald Trump off the ballot in 2024. We talked in the last segment about the lawsuit that has been filed in Florida, arguing that Trump violated the 14th Amendment and thus is ineligible to run. The Politics Brief reports the first Secretary of State is working behind the scenes to keep Trump off the ballot. New Hampshire Secretary of State David Scanlon, a Republican, is consulting with the state attorney general to invoke the 14th Amendment and keep Trump off of the ballot. I will be asking the Attorney General's office for their input, and ultimately whatever is decided is probably going to require some judicial input. This is not new. Every article about this says this is not new. This has been talked about for some time. Is this likely to work in New Hampshire? We just don't know. We really do have to wait for the legal opinion, as Scanlon is pointing out. Is there any conflicted feeling about this? I don't know. I mean, listen, on the one hand, I understand the argument of indictments are just allegations and you are innocent until proven guilty. Innocent until proven guilty in the documents case, the federal election interference case, and the Georgia DA case. The New York state charges aren't relevant to this. They're still potentially criminal acts by Trump, but they're not relevant to this. And so it is certainly the case that in the United States, you're innocent until proven guilty. And there's the argument to be made that trying to remove him from the ballot this early, New Hampshire trying to remove him from the ballot this early, is potentially a strategic mistake. The MAGA people are going to see it. They're going to say Trump's being made, a scapegoat. He's a victim. He's a martyr. He's all these things. They're just afraid of him because he's so good and we're winning so bigly and all of these different things. So it will allow them to start saying the Democrats are stealing the election already. The counterpoint to this is that they have already been saying for a while, Democrats are stealing the election already. They said it in 2020. They said it in 2022. They're already saying that it's going to happen in 2024. And it is so plain what Donald Trump did that you could argue that the constitutional violation, even if not a crime in the same sense that theft or burglary are crimes, that it is such a plain constitutional violation And it is literally in the oath of office that presidents take to say, I will uphold and defend the Constitution, that it makes perfect sense to move in this direction. And to say, forget about the criminal aspects to this. Forget about Trump in Georgia or Arizona or whatever the case may be. He showed such blatant disregard for the laws and institutions and the Constitution. Why should he be allowed to run when he tried to overturn the last election that he lost and actually fomented violence in so doing? That is a difficult argument to contradict. Yes, you can contradict it simply by saying the Justice Department has been weaponized, as all of the right wingers have been saying. You can try to contradict it by making the fact-free claim that Joe Biden directed the indictments of Trump for which there is no evidence whatsoever. You can say all those things, but it's tough to fight against, aside from the practical crimes Trump is accused of committing. He did it in public. We all saw it. He tried to steal an election he lost. Why would he be allowed to run again? I want to hear from you. Strategically, is it a mistake what New Hampshire is doing, considering disqualifying Trump from the ballot on constitutional grounds? Let me know what you think. Leave a comment on YouTube or Instagram or Threads or TikToks or wherever you watch the show. We have so much more to discuss with you today.